Welcome to Mental Health Nursing, Legal and Ethical Guidelines for Safe Practice. We need guidelines because it's not always clear what should be done in all cases in the mental health facility. These guidelines will help us with providing excellent care for our clients. So let's talk about what ethical concepts are. Ethics is whatever is considered right or wrong in any society. And our society may be different from other societies, so we have to keep that in mind too when people come in with different cultural considerations. Ethical dilemma is a conflict between two or more courses of action, each with a favorable and unfavorable consequence, and you have to weigh them out. What is going to be the proper choice? And bioethics are used in relation to ethical dilemmas surrounding healthcare. An example of this would be to use restraints on a client or not. So let's talk about legal admission procedures. So informal admission is something that's sought by the patient. An example of this would be somebody who's looking for help with detox from alcohol or drugs. They can sign something called an informal admission form. And this usually means that if they decide to leave and they change their mind before the detox is completed, that they can go. As opposed to voluntary admission, the patient or guardian still seeks admission and signs a voluntary form to be admitted to the hospital. However, if they decide to leave before the doctor feels they are ready, they may not. For example, if they're still having suicidal ideation or feel like killing themselves or harming themselves in any way, the doctor can keep them there even though they say, well, I signed myself in, why can't I let myself go? And it's because they might be at risk for hurting themselves or someone else. So usually what will happen is the doctor will be called and come evaluate the patient to see if they're ready to go home. And usually there's a compromise reached with the patient and the doctor about when they'll go home and their safety. And the third type is involuntary admission or commitment. This is done without the patient's consent. These people are usually very mentally ill. They're not able to meet their basic needs. They can be a danger to themselves or others. So an example of this would be the clients who are brought in by the police or by an ambulance because of something that happened. Somebody called because they were being unsafe or they were harming themselves or harming someone else. So to admit somebody against their will involuntarily, two doctors need to sign a form. It's called a petition and certificate form, and they have to both agree that it's not safe to let the patient go and that admission is going to be required. Now, this can be challenged. It's called the writ of habeas corpus, and people, their family, or the actual client can actually go to court and file this form and say, I don't believe this person needs to be committed or should have been committed. So it's always best ethically and legally to use the least drastic form of admission if admission is required, and then the least restrictive alternative action. If somebody comes in for suicidal ideation and they say, well, I was really drunk when I said I didn't want to live anymore and I don't really mean it. And they are examined by a doctor in the emergency room when they are no longer intoxicated. And the doctor thinks that it would be okay for them to go home, that they aren't really at risk of hurting themselves. And they think that an action maybe to be discharged to a family member and follow up with a counselor is the best action. Then that's the least drastic then, rather than having the patient admitted to a hospital. Again, it's a psychiatrist's determination what should be done. So let's talk about ethics and legalities for discharge procedures. So a person can be discharged, of course, when they're feeling better, they are no longer at risk for harming themselves or others, they're less depressed, they've gained some coping skills perhaps, and they're ready to go. But sometimes they'll say, okay, you're ready to go, but there's some conditions that we want you to follow. This is called a conditional release. Now, this can be either to go to an outpatient program, maybe, a daytime program 9 to 3, or an evening program, intensive outpatient program, IOP that's called, or even just to see a counselor once or twice a week. You can be discharged if you will follow up, and they have to make an appointment for these things before they're released. That's conditional. Unconditional release is if somebody has filed that writ of habeas corpus and the court has determined that there's no reason for them to be committed. That's an unconditional release. They can just leave. Another unconditional release is the CMO, that's Chief Medical Officer in the hospital. They can discharge somebody based on the fact that the CMO does not feel they need to be there. And this is common a lot of times with homeless people. Homeless people sometimes don't have anywhere to stay in the really cold weather. A lot of them do have mental illness, but they don't always require admission to a psychiatric facility. But sometimes they know what to say to be admitted. They may say, I feel like I'm going to hurt myself, or I feel like I want to kill myself. And sometimes they're on the unit for days, weeks, up to a month sometimes, and they're still saying that they still want to kill themselves. But then when the doctor sees them, they are very social on the unit. They're laughing, they're joking, they're showing the new people around. They have best friends and like the nurses, and they talk to them, and they don't look depressed at all. But when the doctor brings up discharge, sometimes they'll say, oh, you know what, I think I'm still having those thoughts. Yes, it's happening still. So if a doctor determines that they're not really suicidal, which is a big legality for them to take on, they can say, okay, we're going to discharge you tomorrow. And that can happen. It's not all that often, but it can happen. And then the final one, discharge legal, is a release against medical advice, or AMA. Now, you have probably heard about this in medical hospitals, but in behavioral health hospitals, it's a little different. Release against medical advice can be done by those patients who sign themselves in informally, the ones who come in for detox help, for drugs or alcohol, and they change their mind. The doctor may say, you know what, I think it's best if you stay. Your blood pressure is still high because you're still going through detox. And they can say, no, I want to leave. And the doctor will let them go as long as their blood pressure isn't dangerously high. Then he may say, well, I suggest you go to the emergency room. The other release against medical advice is when people say, I want to go home, there's no reason to keep me here, I'm no longer suicidal, but the doctor still thinks they are. They have to sign something called a request for release, and it's also known as a 5-day. In the hospital, they have 5 days to determine whether or not it's necessary for that patient to stay in the hospital. Now, at the end of 5 days, and if it's been proven that there's no reason to keep them in the hospital, they go home. If they still feel there's a need for that person to be in the hospital, they have to bring them to court, and they have to ask the judge for permission to keep them in the hospital. Now, most people feel much better at the end of 5 days of treatment, intensive group therapy, and medication treatment, that a lot of times they are a lot better in 5 days and ready to go home. So this isn't really an issue either, except if patients feel that they've been admitted inappropriately by something they said to a girlfriend out of anger that they didn't really mean. And then it can be a problem. So the patient's rights under the law. They have rights. When they're admitted to the hospital, it doesn't mean they lose their rights. They still have a right to treatment. State and federal law mandates this, regardless of their ability to pay in any way. They also have a right to refuse treatment or medications unless they are a risk of harming themselves or someone else, and there is a danger of imminent harm. And imminent means something's going to happen immediately. They are about to strike somebody. They have struck somebody. They have run into the door at the end of the hallway to try and leave, and they keep injuring themselves or punch something. Then they cannot refuse the treatment or meds because they are hurting themselves. So there's also the right to informed consent. There are so many forms that a person has to sign when they're admitted to the psychiatric unit. And they have a right to all those consents. For example, they have a consent that they have to sign for admission. They have a consent they have to sign for meds. They don't have to. There's a consent that they sign for any procedures that are going to be done, or ECT, or a research program. These are all different consents. They have to be competent and capable of understanding the consequences of their decision. If they're not capable of signing the consents, a guardian that's been pre-chosen or a family member who the patient has given release for information to can sign those consents for them if they are unable to make their own decision. So, for example, I have meds highlighted here because we had an incident where a person signed a consent to be admitted to the hospital. When he was at home, he was taking a medication, an antidepressant called Zoloft. Now, he did not sign a consent for the Zoloft, and he was started on a second medicine, which he signed the consent for. It was new. He later sued the hospital, saying that they gave him the Zoloft without his consent. Even though he'd been taking it when he was at home, and even though he was alert and oriented and they would say, here's your Zoloft, and he took it, he never said, no, I don't want to take that. He still was able to sue the hospital because he didn't sign that consent for that medication. And each medication has to have their own consent. So here's a case study. Let's look at JS. Now, he's a 27-year-old male who's court committed by his parents. They took him to court, and the judge decided he needed to be in the hospital. Now he comes to your unit with a diagnosis of paranoid schizophrenia. He verbally lashes out at staff when they attempt to give him his medications. They say, this is a medicine that the doctors ordered for you to help you with clearing your thoughts. And he states, you're trying to poison me. I'm not taking that. So he continues to argue with the staff. He's not aggressive, but he refuses all treatments. So the legal and client's rights are suspended when a client is hospitalized involuntarily. Is this true? False? Does it depend on the state he's in? Or does it depend on the physician's assessment? What do you think? If you chose B, you're correct. He still has the right to refuse treatment, even if he is psychotic. So the family of JS asks, can't you force him to take his medicine? We want him to get better. And the medicine he's taken before has really, really helped him. Can you please, do that? What do you think that you say? How would you respond? Well, one of the things you would say is, I'm sorry, but we can't force a person unless they are about to cause harm to themselves or someone else. Then we can medicate him without his consent, and we can medicate without a court order if he's at risk of harming himself or others, and that's the only time. So there's lots of patient rights under the law. So a lot of these rights do surround the involuntary commitment that we've been talking about, but also about psychiatric advance directives. So what this is when patients have an illness, say schizophrenia, or say bipolar illness, or say depression, and they come out of the hospital and they've been treated and they're much, much better. But they have a feeling that when they go back into the hospital at any time in their lifetime, the doctors or the hospital might not know what treatment they desire, what's best. For example, ECT treatment works really well for my depression when I develop psychotic symptoms with it. Or these medicines work really well and these don't. Those are the kind of preferences that they can put in a psychiatric advance directive. It's very helpful for all involved, the patient and the staff. So these are some of the most common adopted patient rights in the mental health hospital, but there's some caveats to it, so let's go through them. So they have a right to treatment in the least restrictive alternative, which we talked about, outpatient over inpatient. But if they are at risk of hurting themselves or someone else, they are going to be in a more restrictive alternative. They also have the right to freedom from restraints or seclusion. However, if they are about to hurt someone else, they may need seclusion. If they're about to hurt themselves, they may need restraining. They have a right to give or refuse consent for medication, which we just talked about, regardless of their psychiatric state. They have access to the personal belongings. Now, in the mental health facility, they have a bin that they took their personal belongings in, and they are locked up in a bin room. And these are things that they can't have, like jackets with zippers, sneakers with shoes, sneakers with shoelaces. But they can have things that cannot harm them. Certain things and things that may be used to harm them are locked up, but they can have access to them. For example, some hygiene products like hairspray, something like that. They can say, can I have my hairspray? And then once a day they'll get it out, they'll use it in the nurse or the counselor's presence, and then they'll lock it back up. So they do have access to personal belongings. Daily exercise. They have expressive therapy. They have yoga. They have an exercise type group for clients. Not every facility has an outdoor area, but some do, when they can go outside and exercise. They have a right to visitors. However, the visitors may be restricted. For adolescents, the visitors are going to be restricted to the parents and family members only that are seen to be a benefit for the adolescent's treatment. Visitors are limited to 2 and to adults only, to improve the care. Sometimes exceptions are made. If a doctor feels it would be better for a young woman or a young man to see their young child, then they will allow it for certain circumstances, but in general, no. They're allowed to have writing materials, paper, journals, pencils. Now, usually what you'll see in the mental health facilities, you won't see ballpoint pens because they can be used to injure, and you might see pencils, but they're the little golf pencils usually, because the erasers have metal on them and be used to harm themselves. And that has to be, again, sometimes people have history of self-injury on the self-injury unit. They may only be able to have a crayon because sometimes they'll use the pencil to hurt themselves. And then uncensored mail. They may have uncensored mail, but a lot of it has to be opened in the presence of a staff, because some people send things that could in the mail that could be used to harm them. They have a right to an attorney. They have a right to go to court. They have a right to get paid while they are in the hospital if they are employed. They have a right to confidentiality for staff, for other patients. They have a right for people to keep their business confidential. And they have a right to be informed of all their rights. So some other rights under the law, and the most important for a lot of patients, is their rights regarding restraint and seclusion. Always it's used as a last resort when everything else has been tried. De-escalation techniques, which is talking down techniques. Medications have been offered. Everything else has been tried. All sorts of things. Relaxation, music, whatever else has been tried. Nothing else has worked. It may be a last resort, but the least restrictive should be used. Now let's talk about these. There is physical, which is actually somebody being physically held down, hands-on they call that, which is usually a temporary thing to get somebody to take an emergency medication or to get somebody to not hurt themselves or someone else. If they are not able to calm down, it can progress to mechanical. And mechanical are the ones that you see in the picture here. It's an actual piece of equipment. It's a wrist restraint, a leg restraint, a chest restraint. There's also chemical restraint, which is giving a medication, usually IV or IM, to restrain them and sedate them. And then This isn't always something that is considered a chemical restraint when given. For example, if somebody is given a medication for psychosis, which is normally given for psychosis, that's not a chemical restraint. But if they give somebody an IV dose of Valium to knock them out, which isn't usually used in cases of psychosis, then that may be considered a chemical restraint. Now, seclusion is the last type, and seclusion is when the person is put in a room and not allowed to leave. And they have rooms where there's a window and a door, and you can see the person the whole time they're in the room, but they're free to walk around in there, and you can see them usually in a camera if at the desk. Most hospitals, however, will have somebody at the window, at the door at all times, making sure the person is not harming themselves. Always use the shortest duration necessary for restraint. The person must be released as soon as possible. They also have a right to confidentiality regarding these restraints. They don't want other patients to know they've been in restraints. They don't want people looking at them when they're in restraints or in the seclusion room. So those rooms are kept set off from the rest of the unit so that they can have some confidentiality and privacy. However, they need to be asked, do you want anybody notified that you're in restraints? And they may say, yes, my lawyer, or yes, my mom, or yes, my brother. And those people are notified at the patient's request. So other rights under the law concerning restraints and seclusion are shortest duration, which we just talked about, but there are also legal time limits. For example, people 18 and older can only be in restraints for 4 hours maximum. If they are still extremely aggressive and trying to hurt themselves or other people after 4 hours, the doctor has to be called to ask for a renewal of that order. And then somebody has to come and check that person physically within 1 hour of being placed in restraints, and if it's renewed, again. And this has to be a nurse in a supervisory position, or it has to be a doctor or a nurse practitioner that says it's okay. And then those between 9 and 17 years old, the maximum is 2 hours that they can be allowed and to be in restraints without another order. And age 8 and younger, only 1 hour to be in restraints. So seclusion is an involuntary confinement alone in a room that the patient is physically prevented from leaving. And that's the right-handed slide, the far right. And you see there's a window in the door where they can be seen and things can be given back and forth. And restraints is any manual method, physical or mechanical device, material, or equipment that restricts freedom of movement. On the left, you see the typical old use of restraints, the straitjacket, which is no longer used today. That's how it used to be. But now it's wrist restraints. The middle one is the most accurate for today. Wrist restraints and ankle restraints are used. So the guidelines for the use to review, we said as a last resort, an order and signature have to be obtained from a physician, the psychiatrist, that it was necessary, and a patient relative notified if asked by a client, or if it's an adolescent, the parents have to be notified the person was restrained. Documentation, there are about 20 different forms that have to be filled out, and that's the nurse's responsibility, all the documentation forms. The clinical assessment forms have to be filled out. The person has to have the physical within the first hour. The mental status assessment has to be completed too at that time. Why did they need to be in restraints? What was their mental status at the time? Now, while they're in restraints, they have to be observed very closely, constantly, whether that's at a camera at the desk or somebody arm's reach from them. Different hospitals are different. And there's a flow sheet that has to be documented every 15 minutes. It has their vital signs, their range of motion, the color, movement, sensation, and temp of their extremities that are being restrained and their comfort level. If they have to go to the bathroom, then they are offered a bedpan or a urinal unless they are ready for release. And they are released as soon as they're able to be in control and respond to commands accurately. So to restrain or not, and what methods? Use these guidelines. But to keep in mind, some things are gray areas. For example, to hold someone for a shot, is that a physical hold? Depends on whether or not they're fighting you. If they're actively fighting you, yes, that's a physical restraint. The use of side rails, if all four are up and that's restricting movement, yes, that's a restraint. Standing in a doorway and telling somebody they can't leave the room is a restraint if you block them from leaving. And tying somebody with sheets, if it's physically restricting movement, yes. And there is no such thing as a PRN order or an as-needed order for restraints. It has to be something that the doctor is called immediately for the order, not a PRN. This is an example of a quick release knot that you will be practicing when you go to lab or simulation. And it is what is used in the medical hospital as a quick release in case, say, for example, someone has a seizure and they are aggressive and psychotic and hallucinating, and they need to be restrained due to their safety. That's a medical type of restraint, not a behavioral. So those restraints are different, and I'll be showing you the different types in class. So after the restraint, it's really necessary for the staff to get together and do something called a debriefing. Was prevention possible? Could they have used anything else? Did they use it as a last resort? Was a team approach used? Did they all discuss what they were going to do ahead of time, if it was possible? Also to talk about the staff members' feelings about what happened during that, or who was the leader and did they do a good job at leading and what could have been done different. When there's a leader, only one person talks. The rest of the staff follows cues from the leader. Is this best for the patient as well? Also, they need to check for injuries, and that could be the staff or the patient. And if there are injuries, they need to be reported and they need to be cared for immediately. So they basically talk about how the restraining process went. And if it did not go well, any staff education that's going to be needed to help people see a better way to do it next time. Patient confidentiality, legal considerations. Something that you've probably all heard of is HIPAA. You go to the doctor's office now, or you go to the emergency room, you have to sign a HIPAA form. And the nurse's duty with HIPAA is to maintain confidentiality. And this is very important with mental health, in that somebody can call the desk and say, oh, my father's admitted, I'd like to know how he's doing. The nurse cannot just give information. The person has to look, the nurse or the staff member has to look to see if a release of information form has been signed for that person on the phone so that you can give them information. Otherwise, you have to say, I cannot confirm or deny that patient is here. And does the right to confidentiality after death still apply? Yes. If a person asks you, I think that my husband had a history of being sexually abused when he was younger, can you tell me? Even though he's passed, and people think that, well, now I can tell the family anything. It's not true. It still applies after death. So there are exceptions to this rule. If the person has told you that they want to hurt themselves or someone else, then it is your duty to warn and protect third parties. And if there's a issue of child or elder abuse and the person is telling you they've been abused, then you need to then you need to also notify somebody if this is happening. So the thing that's extremely, extremely important to remember I'm having technical difficulties right now, so this will end the lecture, and we will talk a little bit more in class about documentation and the importance of documentation. And this ends this lecture. What happened? I'm all right. I'm just trying to figure out what happened. Something happened.
Huh?
Something happened. I don't know what happened.